a writ of attachment, a mother refusing to hand over her daughter, and a judge trying to avoid law enforcement showing up at the door. This is a case where a father hasn't seen his 11-year-old daughter for weeks because mom claims there are dangers, but CPS investigated and found no evidence. Now the father has filed for a writ of attachment, which means deputies can physically go to mom's house, take the child, and deliver her to dad. The judge is trying everything to avoid that scenario. Watch how this unfolds.
Attachment, which is a very, it's a very powerful writ because it does allow law enforcement to actually physically go to a residence and to take the child to the other parent. So it's very, very important that we have both parents present. I will say that in my experience, most of the time, the writ of attachment does not actually issue because most of the time when faced with a writ of attachment, parents will be in the position of just going on and letting the child possession schedule go forward. So that's where we are right now. I had a lot of concern about the sheriff potentially coming out or the deputy coming out to the home of mother to pick up the daughter, to take her to father. So rather than do that, we're here and we want to hear a little bit more. So this motion was actually filed by Ms. Preston on behalf of father. Ms. Preston, please tell me your motion and then I'd like to hear from mother in response, okay?
Yes, ma'am. So briefly, our presentation of the facts is that there was an allegation of assault of the child of this suit that was presented to CPS on Thursday, June 15th, which was the Thursday prior to my client's Father's Day possession of the child. CPS conducted an interview on Friday morning around 10 a.m. and determined that there was no outcry from the child and that the allegation of sexual assault needed to be ruled out. And then CPS contacted mom and informed mom that the ruling would be that the allegation was ruled out and that they would be issuing a report to that effect. Regardless of the fact that CPS had informed mom that there was no credible allegation of sexual assault, mom withheld the daughter for Father's Day weekend possession, which is extended from that Friday afternoon through to the actual Monday afternoon because the Monday was Juneteenth, a federal holiday. Since that time, Mr. Jusen has been entitled to possession beginning on Friday, June 30th, and he is currently in stanter entitled to possession throughout the month of July, based on the parties' agreed final decree of divorce, which was entered by the court in October 2022. We've reached out to mom to let her know that we would prefer not to pursue a writ of attachment, that we prefer that she voluntarily turn the child over to dad for his possession time. She has not been receptive to such an offer. So unfortunately, we have come before the court to ask that a writ of attachment be issued. We're also requesting that the court issued the order, but that we still be given time to speak with mom to see if we cannot come to an agreement within the next 24 hours prior to actually moving forward with executing that writ. So we're still hopeful that given that mom is here, that we'll be able to work out the issue and prevent the need for law enforcement to be involved. But in the event that mom is still unwilling to cooperate, we are asking that the court issue that writ so that my client can have, the next 3+ weeks of his extended summer possession.
All right. Thank you very much, Ms. Preston. I do see that the child's mother is here. If you would please provide your response to what Ms. Preston has just said.
I'm sorry, did you request my response?
I did.
Yes. First of all, I wanted to mention that I have not been able to retain an attorney yet, which was part of the reason why I wanted to put this on a hold. However, what I can say is this is not my first experience with CPS. This is not my child's first experience with CPS. I was wary of calling CPS I was told that I was required to call the CPS because it was important for my child's safety. I have been, unfortunately, Your Honor, my child has been. I have had a lot of difficulty trying to keep my child safe in my ex's environment. There has been assault cases happening in his environment that my child was present, but because of financial issues, I was not able to retain a lawyer. I did call the police and report. There have been many instances of Mr. Josan not releasing my child to me because he didn't want to. And I called the police because I could not hire an attorney because of financial reasons. My ex had agreed in his MSA to keep my child directly not to have my child under supervision, without supervision with his child in regards to inappropriate touching. He agreed and signed that MSA. He sent my child for a week with that son without a supervising adult out of state. I have tried to respect the law, Your Honor, many times with the CPS that I did not call. My child's therapist called CPS because they said that it's important. And every time I followed the law to the T, I was not able to protect my child. But and even though I told the CPS this time, I said, my child knows what this is. She gets punished if she tells you anything. She will not tell you what she told me. But they said that they are required to do it, and she did not have an outcry. But the representative told me that she got really uncomfortable when they asked her specifically about the specific inappropriate touching. And I could not, as a mother, Your Honor, I could not willingly allow my child to go. Even after all these CPS cases that have ended in nothing, I could not let my child go to her dad's, knowing that there is a threat, knowing that my child was not going to say anything because she is afraid of what her dad is going to say. He has said, Mr. Josan, that me being ugly towards him, me countering him in regards to the 5 years of child support that he hasn't paid, in regards to any request for him following the decree or his MSA, that it will affect our daughter. He has said that in writing.
Okay, let me ask you this question, because we can't reopen. This is the reason why you're here without a lawyer is because if you weren't here, law enforcement was going to show up at your door. Okay,
I understand.
You need to. That's why I have you here. Let me ask you about CPS. I hear there's lots of disputes about child support and 5 years under the bridge. I can't talk to you about that. I do have a question about CPS.
Yes,
now,
ma'am.
I understand that you're saying that you're obviously very traumatic for your daughter. Anyone would have compassion for that. Anyone would. But do you agree with Ms. Preston that CPS, for the instance that we're talking about, did not find an outcry?
Your Honor, my child chose...
Did they or not?
The CPS representative told me that the child did not tell them.
Okay, then we need to move forward with this. Here's the situation, and I want you to be aware. They have, what Ms. Preston has suggested is that I unless you can show that your husband's not entitled to possession of the child.
Here's what we know. Mom called CPS claiming sexual assault right before Father's Day weekend. CPS investigated, interviewed the child, and found no outcry, no credible allegation. They told Mom the case was being ruled out. But Mom still refused to hand over the daughter for Father's Day weekend and for the entire month of July, despite a court order saying Dad gets extended summer possession for 30 consecutive days. The judge just showed Mom the signed court order from 2022. It's not a suggestion, it's a legally binding order. And Mom is saying she won't comply because she believes her daughter is in danger. But the judge is making it clear, without evidence, this court order stands.
There's a previous court order that says that he gets to see her in July, okay? And we have to comply with that court order. And I hear you and I have a lot of compassion for you that you don't want to do that. Nonetheless, we have a court order. We have to comply with it. I know there was some CPS action. It doesn't seem like that went anywhere. So now we're at the situation where your husband does get to see the daughter that you have with him, his daughter too, in July. So what Ms. Preston has suggested, she wants me to sign that writ of attachment now and to basically give 24 hours for you to comply with it, or the writ's going to issue. I would rather not sign the writ of attachment just yet. I would rather you just agree that you're going to get your daughter over to your husband's house. Can you do that, or is that not going to happen?
Your Honor, I don't have a legal representation.
It doesn't matter at this point. You're here, and I'm listening to you. There's no, I mean, the only other option was not having you here, right? And so it's better that you're here. That's why we're listening to you. So I'm asking you some options right now.
Your Honor, my child's safety is I can't. Your Honor, I understand that I will be legally responsible, but if I have to choose between my child's safety and being legally punished, I would choose myself. I cannot put my child.
I hear you. The situation, though, it's not that it's you that's going to get punished. It's that your child, the deputy's going to come up and pick up your child and take them to, under a previous court order, take the child to father for the month of July. That's kind of where we are right now. Now, if I were an 11-year-old child, I might not really want the deputies at my house. If that's where we are with this, I don't see any other options.
Sorry. Are you saying that I am forced, either whether I want it or not, to release my child to Mr. Josan, regardless of whatever dangers or risks that are facing or could be facing her in that environment, and that the law will not help my child?
But I was asking you about, that's why I asked you about the CPS, and it sounds like that wasn't founded. Okay, that's why we started with that. Ms. Preston, can you please put up the court order that we're talking about here so that we all are on the same page about that?
Yes, ma'am. Okay. Your Honor, can you see the parties' final?
I can see that. I want to make sure that that Mother can see that as well. Can you see that, ma'am?
Yes, ma'am. Yes, Your Honor.
Let's go down and see, Ms. Preston, what exactly we're talking about here.
Yes, ma'am. So if we go down to, sorry if I'm giving anyone a headache, and I'll bypass the father's state possession and just talk about what he's entitled to right now. We're looking at page 9 of the order, provision number 6, extended summer possession. Okay. We're looking at without written notice by April 1st, because my client did not provide any written notice for extended summer possession.
Okay.
And it says if he did not provide written notice of a specific extended period, he is entitled to possession of the child for 30 consecutive days, beginning at 6 p.m. on July 1st and ending at 6 p.m. on July 31st.
Okay. Now let's go to, now did a judge sign off on that order?
Yes, ma'am. The order was rendered in 2018. And then I believe Judge R signed it.
Well, let's take a look at Judge's signature. Okay. So it looks like that this divorce was judicially pronounced and rendered on June 22nd of 2018, and further noted on the court's docket sheet on that same day, but signed on August 5th, 2022. Okay. So this is a court order. Is that what you're saying, Ms. Preston? A court order for a father to have this child, possession of this child in this July. Is that right?
That is correct.
Okay. So that's the issue that, Mom, and I wanted you to see that, because the thing is this has a power of a court order. And if you're saying, I don't want to comply with this court order, I don't want child to go there, then father will be in the position of being able to have this writ of attachment issue, and the sheriff deputy come to your house and pick the child up and take the child to father. And that's hard, going to be hard on a child. So what I'm asking is, wouldn't it just be a whole lot easier on your child to comply with this court order? Because I don't see any way around it.
Your Honor, I hear.
The judge just laid out the reality. There are only two options. Option 1, mom voluntarily brings the daughter to dad's house. Option 2, the judge signs the writ of attachment and law enforcement shows up, takes the 11-year-old child from mom's house, and physically delivers her to dad. The judge is trying to avoid option 2 because she knows how traumatic that would be for an 11-year-old. She's asking mom, wouldn't it be easier on your child to just comply with the court order? But mom is saying she believes her daughter is in danger and she can't in good conscience hand her over. This is an impossible situation.
What you're telling me, my understanding is that you're telling me that basically there's nothing I can do. One way or the other, I will be forced to hand over my child to my ex.
Under this order.
Yes, under this order. So it will either be either be I hand her over myself, or that the authorities come and take her. So there is no third option. Is that correct?
At this point, I'm not seeing a third option now.
Okay.
Yeah. So, I mean, and this is why I'm saying we wanted to get you on this call.
I understand.
I understand you're saying you don't have an attorney. You should try to go get you an attorney. I understand you've got to take care of a sick family member. I totally understand. This, though, takes precedence because your husband has gone and hired an attorney who's going to issue a writ of attachment under this previous court order, which means law enforcement is coming to, if I sign it, which right now I'm not seeing any reason why I shouldn't. Law enforcement is coming to your house to get this child. Now, you, me, your husband, Ms. Preston, we've all been 11-year-old children in the past, and we all know how that would feel. It would not feel good. So I'm trying to impress upon you the importance of this. Maybe just trying to find some space of agreement with Father for the month of July, because that's what the court order that you are under it says. So that's where we are right now.
So can I ask, Your Honor, one other question in regards to this? If you do sign the order, that would mean that the authorities will immediately come to pick up my child?
Pretty quickly they will. Okay. I mean, I would, that's the issue. Now, what Ms. Preston has suggested is that I sign it and give 24 hours for you and husband to work it out. I was really hoping that maybe I wouldn't have to sign it at all. Maybe you would just agree in open court to get the daughter to your husband's house today.
I understand. Okay. So based on the fact that I don't have a representative and I am basically forced to make a decision in this court, I just wanted to say something before I give you my final answer, Your Honor, if that is okay. I am not willingly and in good conscience handing my daughter to my ex, knowing that there are many risks to her and her health and well-being. But because, Your Honor, this is the order of the court, and I have I don't really have another option, as you are telling me, is that either way, I'm damned if I do, I'm damned if I don't. So I am forced to take your advice, Your Honor.
This is not an advice. This is a court order. And I'm not clear. The only thing I'm trying to do is enforce a court order, and that's why I started asking about CPS.
My apologies. Okay. My apologies. I chose the wrong word. And that I will have to accept the court order because I have no other choice. But I just wanted the court to hear my voice and hear my child's voice that I am doing this reluctantly, but I am following the court's order because it is a court order and I have no other choice.
Okay. All right. So let's do this. Ms. Preston, I think what I am going to do is what time is it now? It's 2:40. It's 2:40 and it's Thursday. When do you think you can get your daughter over to your ex's house? How do you all want to handle that?
if it is okay, Your Honor, my child is currently at a not after school, summer camp, and I could go pick her up around 3:30 if it's okay, because I also need to help my brother with his medications. And if, I don't know, 5 p.m. would be okay.
5 p.m. would be just fine. Please get her to your ex's house by 5 p.m. and make sure that she has, her clothes, any medications with her toiletries that she needs, her toothbrush and things of that nature. And if she has a summer schedule that he's going to be following, if she's in the middle of an art camp or something like that, make sure that he has all the information that he needs so that she can continue in her summer activities.
Right.
Okay?
Yeah. The only thing that she has brought with her is her clothes and her phone bag that I will be returning to. Apparently she does have her toiletries and everything at her dad's already.
Good. All right. Well, I definitely, if she typically carries a phone, I want her to keep that phone.
Yes, that should,
Do you
but
understand
that
what
is
I'm
her
saying?
dad's.
That is a court order. If this child has a phone, Dad, I want her to keep that phone. Mom, if she has a phone, I want her to keep that phone.
Oh, so,
It's the child's power. Okay?
okay.
So I don't want any messing around with the child's telephone.
Okay, I'm confused now
Okay.
because that's what I said. I mean, she has, this phone was
Mom,
purchased by the,
Mom, listen to me. We can't see you anymore, but that wasn't for you. That was for Dad. That was for both of you all. I want the child to have her telephone, because if there is some problem that comes up, we're not here in evidentiary hearing. I'm a big believer in kids having their telephones. Okay. And I am suspicious when they don't. So that was not for you, Mom. That was for Dad. But I just want the kid to have her telephone. Okay.
yes,
All right.
that's
So we
what
got that. Now
her.
let's move on. Let's move on.
Sure.
All right. So you're going to get her over to Dad's house at 5 o'clock today. Is that right?
Yes,
Okay.
correct.
All right. I'm not going to sign the writ of attachment right now. Might not sign it at all. But Ms. Preston, if tomorrow comes and tomorrow comes and the child has not shown up at Dad's house by 5 this afternoon, we all know Austin traffic, 5:10, whatever. But tomorrow morning and the child's not there, then I will sign the writ of attachment, and that will get law enforcement involved. But I think that right now we don't need to do that. Okay.
Yes, ma'am.
All right, Ms. Preston, now, are you still wanting to talk about the show calls and the other thing, or do you want to just go forward with this and let everyone enjoy their July and try to do something on the other later? What's your plan?
I'd like to just get the hearing set. Of course, if Mom obtains an attorney and the attorney's not available or anything like that, obviously I'm willing to work with her. I'm also willing to set the hearing out longer than July, especially since my client will have possession now for the month of July.
Yeah.
But if the court is willing to give us a date and order us to appear, I would appreciate that.
Well, I would have to call Mr. Stokes to get that date for you all. Why don't you all do that and find a date? Mom, and I'm sorry I keep calling you that. I don't have names on this one right now. And I can see is very limited here. What she's saying, Mom, is she's saying that since Dad did not get to have your daughter over Father's Day, they're hoping to have a hearing on why he shouldn't have some additional time with her in the future. Did I state that correctly, Ms. Preston?
Yes, ma'am.
All right. So it might be possible, Mom, rather than to have a hearing on that, maybe you all could work something out, like he gets an extra, I don't know how much time she missed over Father's Day weekend, but maybe a little extra time at the beginning of August. That might avoid having to have another hearing on this, and you having to get an attorney to go there. So that would be another option. Do you hear what I'm saying?
Yes, Your
Okay.
Honor.
So why don't you all think about that? Ms. Preston, how much more time are you hoping to have?
We would just be asking for makeup time for the time that's been missed. So that would be or something, 3 days over Father's Day weekend, and then the last 7 days that were missed.
Of July?
Yes, ma'am.
Okay. So let me ask Mom. I mean, I guess one option is we can have another hearing on this. So Mom, what she's saying is that there were 3 days. Can you hear me?
Yes, I'm sorry.
She was saying that there were 3 days over Father's Day, and then there were 7 days the first week of July that Dad has missed with with your child, with the child that you all both are the parents of. And so what Ms. Preston is saying was, gee, Your Honor, I'd like to have a hearing so I could try to get that time back to my client. And I'm just saying, maybe rather than have a hearing, would you agree to let the child stay on another 10 days into August so that you all don't have to have a hearing on that and he makes up the time that he missed with her?
Your Honor, it's very difficult for me to say anything without representative. Is it possible that I have a representative and they communicate with my ex's lawyer?
Yeah.
In regards to this?
Yeah, that's fine. I was just trying to save you all a little time and money, but yeah, that's fine. So what we're going to do, please get your attorney. Do you have an attorney or do you not have an attorney?
At this moment, I don't.
Okay. Well, if you're going to, so you're putting some hoops out there to jump through. Keep in mind, you got to get an attorney and we're going to set a hearing. So go on and get you an attorney and then we can talk about this. The other easier option would be, I think, just to go on and let dad keep the daughter that you all are both are parents of for 10 additional days in August. Another option. Okay. So, Ms. Preston, why don't you go on and draft an order and let's circulate it, send it to mom to look at in that regard, in terms of that being an option. Mom, I will not be issuing any writ of attachment for this child as long as you get her over to dad's house by 5 o'clock this afternoon. Okay?
Yes. Thank you, Your Honor.
Yeah. So we're all squared away for the rest of July. Mom, you might think about, Ms. Preston's suggestion that we just tag 10 days on to the end of this, then you don't have to have any more legal action around the 3 days that were missed over Father's Day weekend and the first week of July. Okay?
The judge did not sign the writ of attachment yet. Instead, she gave mom until 5 p.m. today to bring the daughter to dad's house voluntarily. If the child isn't there by tomorrow morning, the judge will sign the writ and law enforcement will get involved. The judge also made one thing crystal clear. The child keeps her phone. No taking it away, no messing with it. The phone is the child's power. And the judge is considering giving dad 10 extra days in August to make up for the time he missed. Mom says she's doing this reluctantly and under protest, but she has no choice. It's a court order. The judge reminded her, "This is not advice. This is a court order." Was this the right outcome? Or should the judge have waited for more evidence? Let me know in the comments.
Yes, Your Honor.
All right. So, Ms. Preston, you put that together and circulate that. I'm not going to sign the writ of attachment unless things don't happen at 5 o'clock this afternoon or around 5 o'clock. I understand Austin traffic. Mom, you make sure to get the child over there. Mom and dad make sure child has complete access to her telephone, because that's her power. And then let's go on and do that. Ms. Preston, if tomorrow morning comes and goes, and we don't have the child yet, then I will issue that writ of attachment. I'll sign it. Okay. And why don't you get an order over to the mom here on this additional 10 days in August, see if she's willing to sign that rather than to set a hearing and all that kind of thing. Mom, as soon as you get an attorney, make sure to let Ms. Preston know. Okay.
Yes.
So that she has something to deal with. The telephone thing, I'm not putting in an order, but if I have to, I will. So, Ms. Preston, if you want to, put that in an order to me to sign, I'm fine with that. I just feel real strongly about that with kids and their telephones. It's their power. Okay. All right, folks. That's it. Anything else, Ms. Preston?
Yes.
All right.
Nothing for me. Thank you.
All right. Mom, anything else from you?
Thank you, Your Honor. No,
All right.
no.
Thank you very much for your patience and your time, both of you. I know Dad is here too. I know these are not easy discussions to be had, but at least we can go in and get daughter in with father for the remainder of July. Maybe you all can come to some agreement to make up that time lost for the first week of July and Father's Day, and we can get and maybe mom can find an attorney. All right, very good. If there's nothing else, everyone may be excused. Okay.
Thank you, Your Honor. Have a great
Thank
afternoon.
you.
You too. Bye now.